Thank you very much indeed, and welcome to everyone. It's fantastic to see so many of you here in person and also online. Now, obviously, this conference is about the Constitution and governance. And before we gathered here, Rob and I were talking about the Constitution in flux and whether there have ever been so many challenges to the Constitution, certainly since the Second World War, and some might say way beyond that. Think of all the changes that have occurred just in the last six years. Just to whet your appetite, think about the fact that we've got the Judicial Review and Courts Bill going through, we've got possibly a Bill of Rights, which I think Robert's going to talk about, the Fixed Term Parliaments Act, terminated last week. Did anyone notice? But also think about all that Brexit legislation, not just EUA and the various other permutations, but also think too about all of the big acts went through as powers were returned to the UK. Think about the controversy around the Internal Market Act, and then just think COVID. Think about the 550 pieces of secondary legislation that were adopted in that period. And that raises a question for our institutions themselves. Think about the challenges. We know that Brexit was about taking back control to Parliament, but has Parliament really lived up to the expectations that were thrust upon it? Look at the executive, look at the huge powers that have been given to the executive under these increasingly framework acts of Parliament that are being adopted. And then there are the courts, and we're going to hear quite a lot about that this morning. Are the courts overstepping their mark? Are the courts doing politics by another name, or are they simply doing their job? And then there's the union itself. What's going to become of our four nations in the United Kingdom? We know that Scotland and Northern Ireland voted to remain. We also know that Scotland and Wales are very concerned about the implications of the Internal Market Act. Will the Common Frameworks Programme help to ease some of those tensions? And as far as Northern Ireland is concerned, of course, we know the issues around the Northern Ireland Protocol, and also the question about whether it actually operates effectively, whether it's workable to have that border down the Irish Sea. So this raises a question: what sort of constitution do we have? Do we have a constitution of bits and pieces? Or are we seeing, in fact, an increasingly muscular unionism that you find underpinning our constitution, with Westminster very much front and centre? Is it a legal constitution where the courts have really very significant roles? Or is it, as I think Robert has argued, a more political one, which still puts Parliament at the top? Now, all of these issues and more are detailed in our fantastic report. I'm biased, but it's brilliant. And if you want to know the state of affairs on the Constitution today, this is the place to go. Some of the best writers in the field have written in a truly accessible manner over these complicated issues. I'd like to thank Sarah again for helping to pull all of this together, to the SRC and UK and Changing Europe for funding it, and thank you to all our contributors for writing for that report. And this brings us now to our keynote speaker. So Robert Buckland, QC, MP for Swindon since 2010, Solicitor General for England and Wales 2014 to 2019, and Secretary of State for Justice and Lord Chancellor from July 2019 to September 2021. He's been one of the most thoughtful contributors on the fate of the British Constitution and where we're at today. Robert, thank you very much for your time. The floor is yours.
Thank you very much indeed. Thank you. Well, thank you, Catherine, and it's a huge pleasure for me to be with you this morning to open up proceedings. And I think the first thing we must do is to remind ourselves that we're in the privileged position of living in a mature democracy where free and open debate, despite the navel-gazing of the culture wars, remains possible. Now, the fact that the Council of Europe no longer includes Russia is sad confirmation that the Whig theory of history is misplaced, and that the price of freedom is in fact eternal vigilance. Now, I wanted to use my time before you to further develop what was and has been in my mind ever since I worked to implement the government's 2019 manifesto commitment on the Human Rights Act, which I helped to draft. Updating the Human Rights Act was the phrase that we use. Updating, not replacing, you will note. I'm someone who's long defended the European Convention on Human Rights, but I'm also somebody who's advocated further reform and improvement. Now, my address today is the latest in a line of lectures that have been fleshing out my thinking. It's not an issue that can be dealt with in sound bites or media headlines. I believe that we've neglected the details for far too long, and the debate, frankly, has suffered for it. I've lost count of the times when the European Convention has been confused with the EU treaties, for example. Now, Brexit should at least mean that there is no longer any excuse for that. Now, in my recent Society of Conservative Lawyers lecture, I set out what I regard as a key issue with the Human Rights Convention, namely that a wide array of possible interpretations are going to be compatible but not necessarily required by the text or the surrounding preparatory work known as the travaux of the ECHR. And this, I think, is a problem, a challenge with the Convention. It does not so much set out clear rules that can easily be applied, but rather it enacts values stated at a high level of generality and then instructs states to act compatibly with those values. Now, some of those values clash, and so states are required to strike a fair balance between them. Now, when in doubt, and it is first thing in the morning, it's worth going back, I think, to Thomas Aquinas. As he outlined, there are two ways in which positive laws can be derived from natural law. The first is a simple process of logical deduction, very straightforward, and the second is what he termed determinatio. And he explained it with a very neat architectural analogy. An architect takes a general idea, such as a door, and from there constructs a specific door. Now, it cannot be said that the particular size of the door follows as a matter of logical deduction. Instead, a choice has to be made about its precise dimensions. And as Professor Finnis pointed out, that choice involves, in a benign sense, arbitrariness. Now, in his famous lecture, The Nightmare and the Noble Dream, which I've referred to previously, late Professor H.L.A. Hart argued that in many cases, judges simply apply the law, but in others, they have a discretionary field of judgment and actually have a choice to make about what the law should be. Now, given the nature of the open-ended, the nature of the Convention's text, it should come as no surprise that most of the seminal cases involve not a direct deduction from the text, but rather that process of determinatio. The court decides how to further specify the principles represented in the text. Now, sometimes this takes the form of new rules which do not follow as a matter of logical deduction. For example, the duty to investigate breaches of Article 2 and 3. And at other times, it takes the form of broad standards. But the key point is that in all of this, the court is making a choice which is not required by the text itself. The very nature of the enterprise that the court is engaged in has a legislative quality, therefore. Now, if we were starting from scratch, I, for one, would have wanted us to draft the Convention with a far greater level of specificity. And we have some examples of such specificity in international conventions. For example, the UN Convention on Torture, adopted in 1984, which provides in 16 substantive articles what the ECHR does with just one, namely Article 3. Now, while some of the obligations which the Strasbourg Court has fleshed out from Article 3 are indeed present in the UN Convention, there are differences. And it seems to me that applying the principle that a law governing a specific subject overrides a law of general principle, that's the lex specialis, and using Article 31.3c of the Vienna Convention on the Law of Treaties, which means that any relevant international law rules that are applied between the parties shall be taken into account, then the Strasbourg Court, frankly, ought not to have interpreted Article 3 as going further than the UN Convention. Now, the choice of how to specify the Convention rights is, of course, not unconstrained. A further specification cannot be made if it would contradict the text of the treaty. And not all of the articles of the Convention are equally susceptible to such wide specification. So Articles 2 to 7 are already more specified than Articles 8 to 11 and Article 14. But even that constraint gives, in my view, the court an incredibly wide margin of manoeuvre. What should it do then? At one end of the spectrum, the court could conduct the specification entirely by itself. And at the other end, the court could let the exercise of specification be conducted entirely by member states. Now, in such an instance, the court's role would then be limited to considering whether the specification given by the member state could be said to be within the limits of the meaning that the Convention could bear. Now, historically, the approach of the court appears to have been to conduct the specification itself. But following the Brighton process about 10 years ago, the court now affords greater deference to member states. And as President Spano has put it, we are now in an age of subsidiarity. However, we're not entirely at the stage where the court gives the full power of specification to member states. The scope of margin of appreciation given to states is for the court to decide. It does vary, and that variation is not explicable solely on the basis of the text of the Convention itself. In particular, the court uses the concept of European consensus to widen or to narrow the scope of the margin. So, what are the court's key characteristics? Well, I think there are three key features that we should bear in mind. First, by its very nature, the Strasbourg Court has certain limitations to its institutional competencies. This is particularly so in areas such as contentious moral or ethical issues, economic matters, national security and diplomatic relations. And Judges Petschal and Vicek put it so well, and I quote, "Judicial independence is accepted only if the judiciary refrains from interfering with political processes. If the judicial power is to be independent, the judicial and political spheres have to remain separated." And second, the Strasbourg Court is an international court with jurisdiction over now 46 countries. The diversity of legal, political, social and religious traditions between all those countries strongly militates against taking a one-size-fits-all approach. And thirdly, the prospect of amending the treaty to correct an erroneous interpretation by the court is frankly a difficult one. If the court finds that something breaches the Convention, it binds all states. But if it does not, this doesn't prevent individual states from adopting this standard for themselves. So in my view, therefore, the court should continue the process it started at the Brighton Declaration and increase the scope of the margin of appreciation given to states. Furthermore, it should also seek to prune back on some of the specific determinations that it's made in the past and return greater discretion to its members. And in some areas, such as the interaction between the Convention and international humanitarian law, the court has in fact started this pruning back process. Now, sticking to the principle that the best things come in threes, the court's role, I believe, should therefore be threefold. Firstly, it should continue to adjudicate on clear breaches of the Convention, that is, acts or omissions of states that can be established as a matter of pure deductive reasoning. Second, it should give states the widest possible margin of appreciation, which is consistent with the text of the Convention, but it should ensure that states do not go beyond that margin. And thirdly, it can still find that states breach the Convention if the process they took to arrive at this decision was flawed because of a failure to consider relevant considerations or was otherwise arbitrary. And just to develop that third point, to put it in the language of English administrative law, albeit a somewhat imprecise analogy, I concede, the court should construe the text of the Convention so that it gives a very wide permitted field to nation-states, the limits of which being decided on a reasonableness test. But within that permitted field, it can still find a violation because of a procedural failing. When considering parliamentary decision-making, it's important to remember the observation by Lord Reid that, and I quote, "Parliamentary methods of resolving disputes are very different from judicial methods." And that, and I quote again, "Courts have to be careful not to undermine Parliament's performance of its functions by requiring it or encouraging it to conform to a judicial model of rationality." Now, to be fair to the Strasbourg Court, there's been a shift away from the court making its own independent assessment of the Convention towards looking at whether the issues have been properly considered by the domestic decision maker, and I welcome that. But my concern is that some of the principles which the court fleshed out during what President Spano called the substantive embedding phase can cause problems, and indeed would not have been done by the court during its current phase, in my view. Now, to be fair, a lot of these norms are perfectly fine and they're no longer contested by member states. Nonetheless, the court needs to engage in both a formal and an informal dialogue with the states to prune back some of those norms that can frankly cause difficulty. The Convention requires an assessment of whether a restriction on a qualified right is proportionate. That is, does it strike a fair balance? And as the late Sir John Laws pointed out, and I quote him, there is real difficulty in distinguishing this from a political question to be decided by the elected arm of government. The solution to this problem, as Lord Reid has said, is a strong dose of, frankly, deference, grounded in due respect for the differing roles of the court and of Parliament. Comity is the word that I've often deployed, which is well familiar to many of you. And there are, therefore, I think, there's one first order and there's one second order question. Now, the first order question is, how should the correct balance be struck between the public interest and competing rights? And the second order question is, how wide is the decision maker's discretion in answering that first order question? Now, since the first order question is frankly political and doesn't have a single right answer, it should be answered by the political branches of the state, or at any rate by bodies under the control of the political branches. The second order question, namely how wide is that discretion, is one for the courts, both Strasbourg and our domestic courts. However, there are some unfortunate instances where courts or other non-political bodies have been required to answer that first order question, and there are two that I will focus on. The first, frankly, arises because Parliament hasn't done its job properly and has not answered the first order question, so that other bodies are required to do so, and I've made this point on numerous occasions. The leading example is the development of the tort of breach of privacy. Under the test as developed by the courts, applying the Convention principles, a court must strike a balance between the claimant's Article 8 privacy rights and the defendant's Article 10 freedom of expression rights. Now, these are two values that do not have a common standard of measurement. How to strike the balance between them is, in my strong view, a political question. This is an area of quite a bit of controversy, to say the least, particularly at the moment. And as a result of those decisions, the courts are thrust into the limelight. It is not fair, frankly, to ask our courts to strike that balance without any guidance from Parliament. Now, of course, I concede that it would be unrealistic to have legislation that sets out rules that cover every possible permutation. There necessarily will be a certain amount of discretion. But there's a difference between court discretion that is bounded by factors identified by Parliament and an unbounded one in which the court is asked alone to strike a fair balance between two important rights. Now, I note that the government's human rights consultation wants to strengthen freedom of expression vis-à-vis privacy, but it seems to me that the best way of doing so is to legislate to say precisely in what sort of situations the privacy interests will outweigh the freedom of speech ones. And we've got a good example of Parliament legislating to provide a scheme which balances the public interest and human rights. And that's the good old Police and Criminal Evidence Act of 1984, an act with which I became very familiar in my criminal practice. Take detention prior to charge, for example. Now, PACE provides that the maximum length, outside of terrorism cases, is 96 hours. It provides certain tests and safeguards that need to be made in order to continue detention up to that maximum point. Those provisions of PACE are Parliament's specification of the political issue of how to balance the liberty of the individual, which finds expression in Article 5, and the public interest. And this provides a relatively straightforward tool for lawyers, police officers, magistrates and judges to apply. It would be infinitely more complicated if police officers or magistrates were required to consider whether further detention would strike the right balance between the liberty of the subject and the public interest. And as the authors of the excellent book, Legislated Rights Securing Human Rights Through Legislation, have pointed out, since the European Convention is incompletely specified because it is too vague and open-ended, it needs further specification, and that specification needs to be done in the first instance by legislatures. And as they say, and I quote, "Human rights need positive law, not only to add security for the respect of the rights of persons, but also to realise, by specifying in law, the requirements of human rights. Legislatures should be understood as full partners in this enterprise of promoting and protecting human rights, and not as a standing threat to rights against which courts must serve as guardians," close quotes. Finally, the issue can arise where the courts make an improper use of Section 3. When Parliament has engaged in specification, the task of the court should be to apply that specified scheme, and they shouldn't seek to directly apply the rights that have been so specified, whether they be convention rights or rights under common law. To do otherwise, in my view, would be to usurp the role of the legislature. Now, the Human Rights Act gives the ability to the courts to consider whether the statutory scheme is itself compatible with convention rights. Now, such complaints can therefore be considered, but subject perhaps to Section 3, they ought to do so without disturbing or modifying the specified scheme that Parliament has created. Now, in such an instance, the question that the court could ask itself is not the first-order question of how the balance should be struck, but rather that second-order question. Does the outcome, which the parliamentary scheme gives in this particular case, go beyond the margin of appreciation which Strasbourg would grant to the UK? Now, if the answer to that question is yes, then the court must then consider what should be done. Now, it can use Section 3 to, if the defect in Parliament's legislation is a minor one, and correcting it would be possible. But what is possible has to include constitutional constraint. Now, it's one thing to make use of Section 3 so that, for example, an additional factor can be considered because new case law from Strasbourg says it ought to be, but it's quite another to use it to read in a requirement that the primary decision maker should themselves conduct the proportionality analysis. Now, doing so amounts to undoing or usurping the legislature's specification. And I was concerned that, for example, through the use of Section 3 and Section 6 of the HRA, the Supreme Court said last year that a court, when trying someone for obstruction of the highway, ought to consider for itself whether the arrest and removal of the protesters struck a fair balance between the rights and interests at stake. Similarly, in a recent case, the High Court has held that the police are obliged to conduct a proportionality assessment themselves when policing protests, even in the context of the COVID pandemic. When it comes to protest, the Public Order Act is Parliament's specification of the balancing act between the right to protest, the rights of others, and the public interest. It is that the police and courts should be applying, and not a general proportionality assessment. Now, the question of what is a fair balance between the rights of some to protest and the rights of others to use Her Majesty's highways is one which, as Lord Reid put it, involves, and I quote, weighing up incommensurable factors. And so it doesn't have a single right answer. Now, reasonable people, and that very much includes judges, by the way, can and do disagree over how such a question should be answered. In a democratic society, that decision should be made by Parliament or by ministers who are accountable to Parliament. These constitutional considerations mean that courts should strive to reach interpretations that do not require them or other public authorities not directly accountable to Parliament or to the people to answer those first-order questions. Furthermore, this sort of weighing up of factors is contrary to legal certainty, and it seems to me, on that basis, it is also contrary to the rule of law. For if the rule of law means anything at all, it must include, as the US legal academic Lon Fuller argued, governance on the basis of rules. Now, it must be recognised that it is not possible to always ensure that a public authority would never have to consider that first-order question itself. That is because it is unrealistic to expect Parliament to provide a specification for every single possible issue that might arise. But where Parliament has occupied that field, its own scheme should be applied in place of a first-order proportionality analysis by the court. And that's why I'm in total agreement with Sir Peter Gross's recommendations in the Independent Human Rights Act Review report that before going to convention rights, the domestic court should first apply UK statutes and the common law. This is because our domestic law contains the specifications that Parliament has provided, or which, within their narrow role, our courts have done in developing our common law. Secondly, the domestic courts must continue to remember the distinction between that first-order proportionality question and the second-order one. Whilst the decision in the case of Ziegler is not ideal in that regard, the judgment in SC is, in my view, preferable. There, the court recognised that the answer to the first-order question was ultimately political, and it was one which the court was not competent to answer. It therefore confined its analysis to the second-order question, that is, how much margin does Parliament have, and does that decision fall within the margin? But how then should the court approach that second-order question and its link to the Strasbourg Court jurisprudence? Now, as I said in the SCL lecture a few weeks ago, the domestic courts can frankly go wrong by gold-plating the ECHR, either by finding violation in instances where it is not clear that Strasbourg would find a violation, or by holding that they can still find a violation in matters falling within the UK's margin of appreciation. Now, fortunately, last year, the Supreme Court has corrected both of those errors in the cases of AB and Ellen Kane. Now, the role of our domestic courts is to determine what are the UK's international obligations under the ECHR without needing a trip to Strasbourg, and subject to Parliament having decided otherwise, to prevent public authorities from acting contrary to those obligations. It's not the task of the courts to decide for themselves what they would like the rights listed in Schedule 1 of the Human Rights Act to mean. Those rights do not have an autonomous domestic meaning that is for our courts to figure out. This was, and I use this word advisedly, the heresy rightly rejected by the Supreme Court in Ellen Kane. Now, this, of course, does not mean that the UK court should be bound by every decision of Strasbourg, not least because the Strasbourg court is itself not bound by its own decisions. It's important that there is space for judicial dialogue between the courts, and that dialogue must inevitably include occasional disagreement. But the framework under which such dialogue must take place is one where one asks what the UK's obligation under a particular treaty is, and the judgments of the court, given the task of interpreting that treaty, must necessarily take pride of place. Now, if our courts forget this, or if our Parliament instructs them to treat the rights in Schedule 1 as having some autonomous domestic meaning, there will be two very undesirable consequences. First, it will very likely lead to our courts going beyond Strasbourg, as we saw prior to the cases of AB and Ellen Kane. And secondly, it will upend the constitutional position of our courts because it will require them to come up with what they take the meaning of a vague, open-ended text to be. And that will inevitably put them in the position of making judgment on the merits of parliamentary action. It's not good for our constitutional balance. And it is for this reason that I am very concerned that the government is proposing to replace the Human Rights Act with a Bill of Rights, which will have the same text as the ECHR, but which, at least according to some aspects of the consultation document, which will have an autonomous domestic meaning, which should be determined without reference to the Strasbourg case law. Now, as Richard Eakins and John Larkin put it recently, prior to the recent change in jurisprudence of the Supreme Court, the domestic courts were, and I quote them, increasingly approaching the HRA on the footing that it empowers them to develop a kind of British Bill of Rights chosen by our judges themselves, which would gold-plate the ECHR, imposing further limits on government and Parliament. Yet it would appear that this is what the government is now consulting on. The proposed Bill of Rights will retain the same text as the ECHR, but, at least according to some aspects of the consultation document, it would have an autonomous domestic meaning, as I've said. This would undo all the gains that have been made in recent Supreme Court decisions. I strongly agree with the responses to the consultation from my friends at the Society of Conservative Lawyers and indeed of Policy Exchange, which advocate codification of those recent Supreme Court decisions rather than giving those rights an autonomous domestic meaning. And now, to be fair, the government did also contemplate codifying the principles laid out by the Supreme Court in AB, and Ellen Kane was a case handed down the day after the publication of the consultation document. So I very much hope that in the light of that particular development, the government opts for this course of action. To conclude, therefore, the domestic courts should do well to remember Lord Reid's observation in a number of cases that whilst the HRA might have given the courts more power, it has not removed the limitations of the court process to decide certain issues, nor has it altered the relative institutional competences of the courts, executive and parliament in relation to their composition, to their expertise, to the procedures, accountability and legitimacy. It is unfortunate that those observations were made in dissenting judgments, but it's heartening that they now seem to represent the unanimous view of the court, and long may that last. As for government and parliament, I do not think that we should seek to replace the Human Rights Act with a Bill of Rights. Doing so runs the risk of introducing an autonomous meaning doctrine, and this, frankly, would upset the constitutional balance. Instead, the starting point of the government should seek to codify the new approach of the Supreme Court. There are then other changes that might be worth doing to the HRA framework, some of which have been suggested by the Gross Review. And another worthwhile change would be to legislate to overturn the case of Ziegler unless the courts beat us to the correct course before Parliament does so. And Parliament must also be much more willing to engage in specific changes. It should do this, to start with, in areas such as privacy law and deportations under both Articles 3 and Article 8. And in the course of doing so, ministers must not be afraid to make a Section 19(1)B certificate of incompatibility. At the Strasbourg level, now that Protocol 15 is in force, it ought to be full speed on the move to process-based review. And in the course of doing so, the Strasbourg Court should be willing to revisit some of the norms it developed during its substantive phase, if these pose problems for member states. And in parallel, the UK could work with other member states to identify some of those problems. This could form either the basis of a new protocol, or it could persuade the Strasbourg Court to revisit its case law. In short, we should abandon the uncertainty of a Bill of Rights, make targeted and specific domestic reforms instead, and seek to work for further reform at international level. And that, I believe, would be a truly Tory approach to human rights reform. Thank you.
Thank you very much indeed, Robert, for a fascinating, insightful and thought-provoking talk. Before I proceed, can I urge you to ask questions on Slido? For those of you not familiar with the technology, you use your phones to pick up the QR code. You type your question in, whether you're in the room or you're online, and magically it should appear on the iPad that I have in front of me, which at the moment says you can be the first one to ask the question. So please, could you ask questions? Otherwise, it will be a monologue from me, which will be much less exciting. So just to pick up, Robert, from what you were saying, my understanding is that you were making the point that Parliament should be more prescriptive when talking about areas where there's an impact in the human rights field. But what we've also seen in recent years is that, dare I say it, Parliament has been surrendering power and adopting increasingly skeletal or framework bits of legislation, which puts a huge amount of power in the hands of the executive. And that seems to go against exactly what you're advocating.
Well, that's a very fair point, Catherine. I think we know some of the reasons why this has been increasingly happening. I came into Parliament 12 years ago, well into the era of the programme motion, which, of course, was a device created by the Labour government in order to really entrench the government's control over time. As you know, time is everything in the House of Commons. And the government's stranglehold over time and its ability to constrain and constrict time means that it's a self-fulfilling prophecy that because of that control, then there's an argument to say there isn't time and space to really go into the warp and woof of detail, which is I think, one of the rather prosaic reasons why we've ended up in this position. And of course, the House of Lords rightly rail about it. I think, to be fair, I think certainly when I was in government, we always took great care on Henry VIII clauses, which, as you all know, are self-cleaning clauses that can amend primary. But of course, that's not the end of it. That's not the end of it by any means. And therefore, I do think that, now I'm out of government, I'm able in this time of introspection and self-criticism to say we can do it better. And I think in the field of privacy, which is the one I'm referring to, I think there's been an abrogation, frankly, or an abandonment of a parliamentary involvement on the basis that it's too hard. That's the argument that I've often heard about privacy, that it's too difficult. Well, if Parliament isn't doing difficult, then why are they there at all? And therefore, I do think, if we're going to, recast and consider this carefully, then it is a time for Parliament itself to revisit its mechanism, if indeed, as I think it should be asserting its authority in this particular area.
Joshua Rosenberg's asking if Dominic Raab declines to accept your advice, do you think he will get his proposals through Parliament in the next session?
Well, the consultation period is still ongoing. I do think that there is genuine debate about it. I think that I'll be frank with the notion of a Bill of Rights. It's a very 2015 response to a 2022 issue. I think that whilst it was a matter of hot debate, if you remember, during the coalition, and we had that very odd commission, if you remember, with a huge range of different views that was almost designed not to come to a conclusion with respect to everybody on it. I think that the moment for all of this has passed. What is actually the problem that is trying to be solved? Is it an attempt to fill the margin of appreciation by the UK? That might be a respectable argument for it, so that we can have a very clear rationale that we can then display to Strasbourg if a particular aspect of our procedures comes under attack. Or is it window dressing? That's a criticism you could apply to it. I think the main problem with it is the one that I've identified, that it could inadvertently, I think it's inadvertent, give rise to reviving this theory that somehow this is a fresh set of rights that need to be interpreted by the courts domestically. Disaster. And the old wartime analogy, is your journey really necessary? I think the answer to it is no.
I mean, obviously, you're very concerned about the courts intervening too much. You've always advocated the important role for Parliament. But what happens if the courts do go down the route, in your view, and do overstep that delicate mark? I know Lord Reid has showed signs of something of a retrenchment, but of course he's not alone, and there are others who might take a different view. Well,
I think I've always held up, and it's not shroud waving, I've always held up the nightmare scenario of a political court. Our Supreme Court is not a constitutional court. It's the Court of Final Appeal for the United Kingdom that deals with the questions that are put to it, and it seeks, I think, very well to answer the question. It doesn't try and roam over the constitutional savannah or come up with general principles. It's a very, focused court, and that's such an important thing. And it does mean, I think, however, a certain amount of responsibility to make sure that we can keep it that way. And I don't know about you, but I would be horrified if we ever saw the day coming that a committee of Parliament started scrutinising judges for their perceived political bias or their political view. I think that would lead to, frankly, a massive diminution in quality and in the reputation of our courts, which I certainly, when I was Lord Chancellor, felt very fiercely protective of. And I think it's the job of government to do whatever it can to protect the judiciary, to support them, to make sure that their independence and their world-leading role is maintained. So I think that is the most clear consequence if we end up with what I've characterised as an overstepping of the mark.
The most popular question that's come in is by a contributor, and forgive me, I may well mispronounce your name, Paul Odwiba, I apologise for the pronunciation. And this touches upon an issue that, of course, you've alluded to but not gone into, which is new areas where the courts have to go into. Miller 1 and Miller 2, of course, were examples of that. And his or her, and forgive me, I don't know, a specific question is, should the Prime Minister have resigned and failing that been sacked by the Queen when he was shown to have lied to her about his motivation for proroguing Parliament?
Well, I'm not going to get into a definition of a lie. I don't think that was the question. I think the question was a lack of a rationale for the length of the prorogation. This was going to be one of the longest prorogations since the war. There had been, I think John Major had prorogued actually for quite a while, but I think everybody understood that that was coming close to an election. In the end, I think the court just wasn't persuaded. I mean, actually, when you look at Miller 2, there wasn't that much evidence before the court. I don't recall the swearing of affidavits or the giving of evidence about the rationale or the reasons. And you know, to be fair to the court, although there are aspects of that judgment I strongly disagree with, it wasn't left with much actual evidence to work on. And therefore, what it did was substitute its own principles for convention. That's in essence what happened. I've said before that although it was a tense and a tetchy time for everybody involved, it was an example of the Constitution working. It was an example of the government actually accepting the decision of the court and Parliament reassembling in accordance with its ruling within a day or so. And therefore, I never thought at any time it was a question for prime ministerial resignation. I think it was, I'm afraid, one of the aftershocks of the seismic event of Brexit. And, you know, we had a number of aftershocks with which I'd had to deal with during my 2 years or so in office.
Thank you for tackling that. The questions come in from Vijay Srao. How can you have better justice if courts are closed and sold off to property developers?
Well, I'm going to shamelessly remind everybody that, of course, the court closure programme wasn't on my watch. However, do I think that it was wholly misconceived? No, I don't. I think that whilst I think it's glib to say that we can just casually rush to digital and remote courts, though, you know, COVID has advanced that cause hugely by necessity, I do think that where we are now is striking more or less the right balance between the need for local courts and actually some more strategic and sensible management of what is a vast property portfolio. Now, the HMCTS is just an incredibly large landowner, it seems to me. I think that I think coupled with quite low maintenance budgets, we'd ended up in a position where a lot of our courts were looking very tired. And I think those working in the courts felt very, very much neglected, and frankly unloved. And there have been, certainly when I took office, big strides to increase the budget, to improve the maintenance of our courts, and to maintain the network. There's no current plans to close any further courts, certainly not developed in my time in office. And now, I think, post-COVID, it's time to blend the best of remote technology, and it's developing all the time in ways that are making it much, you know, better for judges and court users to engage with, and that need where, in particular, a witness has to be assessed for their credibility for those in-person hearings. So I think the world has moved on quite considerably from that court closure programme of about 10 years ago. It's now really about quality, I think, rather than quantity. And that's why I don't think we're going to go back to a position where we'd have, for example, Eglwyswrw Magistrates Court, which I remember in Pembrokeshire, which was next door to a pub, and the retiring space for the magistrates was indeed the lounge bar of that wonderful pub. I mean, it's romantic stuff, isn't it? But much nostalgist that I am, I don't think we're going to go back to that.
But there are real tensions in the criminal justice system and indeed the civil justice system. We know the huge delays in both fields. And we now know that criminal barristers have decided to take industrial action because of the lack of legal aid funding. How do you feel about that, and how do you respond to the criticisms that the judicial system, the court system has been systematically starved of funding?
Well, I mean, as somebody at the criminal bar who themselves took part in action back in the noughties to refuse to take new cases, and certainly in Cardiff we held out for many, many months as outliers in action relating to what was then, frankly, a systematic underfunding of the graduated fee system. I have a lot of sympathy for my colleagues at the criminal bar. However, I think that bearing in mind what has happened and the actually very productive report of Sir Christopher Bellamy, which has, as a minimum, recommended an injection of 135 million into the system, particularly for those criminal solicitors firms that are really on the edge and who are crucial for the survival of the market if we are going to maintain private provision, rather than a criminal defenders service, which would be, I think, a problem and not a good way forward. Then my advice would be to hold back actually from action. The Criminal Legal Aid Part 1 review, which I implemented, did increase funding for criminal fees, and that was the first increase in many, many years. And the Bellamy recommendations represent a further increase in criminal legal aid, which is hugely welcome. My view is that the government needs to get on with it. I think they want a 12-week consultation period. I think if there's unanimity about the benefit that Bellamy brings, then surely they can, I think with sense, reduce that period a bit and try and get on with implementing the statutory instruments that will bring in these much-needed increases in fees. Now, I get the frustration of the bar, I really do, and I get the fact that they feel unloved and neglected over a very long period of time, not 10 years, but 20 years. But I think that certainly in the time that I was in office, I moved heaven and earth to try and make sure that we were able to turn a corner and start to increase that funding. And that is what now, happily, is occurring.
Thank you very much for that. The questions are actually pouring in, and I apologise to all of you for not being able to get to them in the course of this session, but some of them will be answered in the course of today. But Sir Robert, the most popular question that's come in, and I give you, it's the last one that we can tackle now, is from Fatima Barber, who says, "You've expressed your confidence in this government previously. Is this sentiment unchanged?"
Oh, I have. I think I did the Oxford Union debate, the no confidence debate in October, and I put it in this way. I said, had I been asked to take part in the debate when I was still a member of Cabinet, I would have had an extremely high degree of confidence in the government. I still have confidence in the government, but inevitably it's perhaps slightly less than when I was there, shall I say.
Is that because it's missing your expertise?
I'll leave that for others to comment. But I do have confidence.
In all matters?
Well, I've outlined an area where I think we need to have a proper debate. I think that I'm concerned that the focus that I wanted to place on the Constitutional Reform Act of 2005 is being lost. I think there are opportunities, if you're a Conservative Lord Chancellor, you want to do things that mean something in terms of maintaining a balance in the Constitution. I'm just worried that in the pursuit of headlines, we're not actually going to make some of the meaningful changes to the Constitution that I wanted to do. And I think rather than chasing chimeras such as trying to change retained EU law, for example, or introducing bills of rights, far better to have a look at the mess of the 2005 Act, restore the position of the Lord Chancellor, and do things that actually, are A, I think, quite Tory, and B, quite sensible in terms of maintaining the balance in the Constitution.
And if the Prime Minister gets a penalty notice as a result of Partygate?
Well, the notices are coming out in part today, I say. I'm not sure whether we're going to hear much about the PM. I think, I put it in this way, I think it will depend very much upon the circumstances. And on one level, you can say that if he does get it, it is an example of equality before the law, and that actually it's an example of the rule of law working. So I think I'll reserve judgment on that until I see the full implications.
But he was keen for Mr. Hebblethwaite to go over the P&O dispute for breaching the law. Perhaps he might think about his own position?
Well, I think any head of government who is found to have infringed the law has got some explaining to do. Let's see what the explanation is. And as I've said, be you ne'er so high, but the law is above you. And that will be the case here, I'm sure.
Thank you very much indeed, Robert, for kindly tackling all of those diverse range of questions. Thank you to you all for your questions. Please stay with us. We have the next panel is on the very specific question of the role of the courts. And so may I invite the panellists to join us on the stage. But could I invite you all to give a round of applause to Robert Buckland. Thank you very much indeed.
Thank you very much. Thank you, Catherine. Lovely. Real pleasure.